This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Lestrange and Graucob. It was about a vending machine being installed, and someone had said they weren't going to, or they were going to install another. The principle is that if you sign a contract, it's up to you to make sure, because if you sign a contract, you've no escape. That technically is not correct. It is possible to escape. I mentioned yesterday, if the fact that you know that I can't read and I don't have my glasses, I can read as long as I have my glasses. If you know I don't have my glasses and therefore can't read the contract, then you cannot rely on the contract because you knew that I was not able. And if you falsely tell me the terms of the contract, then I have a claim to say I should be allowed to escape it. But it's unusual. And if you sign a contract, if it's a contract for the sale of books, for instance, and I sign a contract not being able to read it, and instead of buying 10 books, you've written 100, I have no escape. If, on the other hand, it is a contract for the sale of a shop instead of books, then I have a valid escape. So it's got to be fundamentally different in nature. The contract which I sign must be fundamentally different in nature than the contract which I thought or I was wrongly told. And again, we've got a little bit of Latin. Non est factum is my defense. This is not my deed. I have signed this contract, although I was wrongly told that it was a contract for the sale of goods. In fact, it's a contract for the sale of a shop. So if I was wrongly told, I can plead non est factum. But it's rarely available. It's only available for a person with, for instance, a physical impairment where you knew that I couldn't read it because I didn't have my glasses, and you falsely told me that it was a contract for the wrong thing. But if it's 10 books and you've written 100 books, then that's not fundamentally different. It's a contract for the purchase of books. So it's got to be something completely different in order that I should be able to claim non est factum. This is not my deed. Oral statements by an employee, the fifth bullet point on page 29. An oral statement by an employee can destroy the effectiveness of an exclusion clause. In the case Curtis and chemical cleaning, Curtis is another one of these names. It's a man's name, particularly a man's name. In America, there's a very famous golfer called Curtis Strange. I'm not sure if he's still alive. Curtis Strange. So Curtis is a man's name, and therefore you find it in your names list. I'm just having a look here. Yeah, there's a word in here, in this little dictionary, the word sequin. And that's what this case is about. It's about sequins. And a sequin, a life-size, well, I'll draw it life-size on my screen. A sequin is a glittery little thing with a hole in the top. And ladies typically, although there's no reason why men shouldn't, but ladies typically will sew these glittery things onto their clothes so that when you go dancing and you've got the revolving light, it will glitter off your sequins. And that's what this case is about. It's defined in this dictionary as a small ornamental metal disc on a garment. Okay, and I see quite a lot of them in this part of the world, that it seems to be not unusual for ladies to have garments which have got sequins sewn on them. Just think about your own wardrobe. Now, you ladies, just think about the wardrobe you have at home. Do you have any clothes with sequins on? Do you have any clothes made of hessian? Of course you do. And you may sew the sequins onto your hessian dress. That's what this case, Curtis and chemical cleaning, is about. It's about a woman who is then going to enter for a dance competition. And she had a dance dress, and it was a beautiful dress, and she spent hours sewing sequins all over this dress so that she was all glittery and beautiful. And she thought, well, if it's an important competition, what I will do is I'll take the dress to the cleaners, and see if they can clean it and make it look really, really beautiful. So she took her dress along to the cleaner, and she's looking behind the receptionist at the wall, and there's a sign on the wall that said, "Notice is hereby given that the chemical cleaning company will not be responsible for any loss or damage to customers' garments." And so she asked the receptionist, she said, "What does that mean actually? What does that actually mean?" And the receptionist said, "It means that if we get this dress back from cleaning and your sequins are damaged, or even one sequin is damaged, or all of them, we are not going to be liable." Oh, well, what do you do? Do you risk it? Well, it's a big competition, and she wanted a clean dress. So she said, "Oh, all right, I'll take the risk." And the dress was ready on the Friday, the competition on the Saturday. There's the dress, and she opened it up, and not a single sequin, not one, was damaged. Not one was damaged. They were all perfect. But there was a big black stain in the middle of the dress. So she sued the cleaning company, and the cleaning company relied upon the exclusion clause and said, "It says there clearly that we shall not be liable for any loss or damage." And Curtis said, "Yes, but I asked, and I was told by your receptionist that this would mean that my sequins would, if they were damaged, you would not be responsible. You didn't say anything about putting big black stains on my dress." So Curtis won. The oral statement of the employee destroyed the effectiveness. If the employee had said, "It means that if your dress is damaged in any way, then we will not be responsible," but that's not what the receptionist said. She said, "If we damage your sequins, we shall not be responsible." Where parties have a history of trade, the other party may be deemed to be aware of the exclusion clause. Okay, Sperling and Bradshaw. This is about the storage of orange juice. I think I've got the right case. I think it's about the storage of orange juice in a warehouse. And the person had dealt with them for a period of time. And when he went to collect his orange juice later, the barrels were empty. Are you checking up on me there? Am I right? It is orange juice. Good man. The barrels were empty, but it was deemed to be the case that because we had dealt with them before, we should have been aware of the exclusion clause, even though it was not brought to our attention every time we went and put goods into storage. Because we have dealt with them before, we were deemed to know about the exclusion clause. But then there's a sort of exceptions on that. This course of trade, if there is a history of trade, the course of trade or the history of trade should be more, on the next point, should be more than 3 or 4 occasions in the previous 5 years. And Hollier and Rambler Motors, Hollier took her car in for repair, and there is an exclusion clause within the Rambler Motors contracts that says that they will not be responsible for any loss or damage, and they actually specified, and caused by fire. And I don't know how, but her car caught fire, and the exclusion clause was called upon. They said, "No, we deny liability. You should have known about this, even though we didn't bring it to your attention. You have dealt with us for 5 years. And she said, "Yes, but only 3 times or 4 times in 5 years. I can't be expected to remember the fact that you have got an exclusion clause in your standard contract." And she won. She won. That a course of trade may exist, but it's got to be more than an occasional course of trade. That goes on, the next one, that's Hardwick and Suffolk. This is where they had a course of trade of 100 times in a 3-year period. That's 1 every 10 days. So they should have known about the standard exclusion clause. Did you ever see the film The Sound of Music? You did. What was the name of the singer, the female singer, the lead singer in The Sound of Music? Julie Andrews. Do you not remember? No. Well, there you've got your next case, Andrews and Singer. Singer is a type of car. It's a model of car. I think they're no longer made. I'm virtually certain they're no longer made. But a Singer is a type of car. So it's in your Christian name list, and it's also in your cars list. And Andrews and Singer said that they would not be responsible. There's an exclusion clause for any new car that was sold. They would not be responsible for any new car that was sold. And when Andrews bought this car, there was, I think, 80 kilometers on the clock. Does a car... I'm going to sneeze. I'm just about to say, I can feel one coming on. Will you excuse me? Just 1 minute. I may not. Oh, yeah, yes, I am. Oh. Now, there'll probably be 2 more, because I normally sneeze in 3s. So if I have another... Oh, God. Just excuse, talk amongst yourselves. It's there. Oh, you put your finger there. You put your... I've got to put my finger there? Do I have to push? Or just touch? It's gone, it worked. Thank you. Any ambiguity? Is a car with 80 kilometers on the odometer, is that a new car? No, it's got 80 kilometers on it, and therefore it's not new, so Singer was not able to rely upon the exclusion clause. And finally, it is possible to exclude liability for absolute total non-performance, fundamental breach, major breach. It is possible to exclude liability. It was thought not to be possible until a case came up, and it's called, and you'll see why it's called the Suisse Case. And it's called the Suisse Case because the full name of the case, I'm not write it down, but the full name of the case is Suisse Atlantique Société d'Armement Maritime Société Anonyme and the MV Rotterdamsche Kolencentrale. So it's called the Suisse Case. And the Suisse Case was about a matter, a dispute, and it's a very strange word. Very strange word. I don't believe that many English people will know the word demurrage. Demurrage, you know it? Good God. The first person I met that did know the meaning of the word demurrage was a man I met in a bar. This sounds awful. It's a man I met in a bar in Turkey, of all places. And he was a Turkish sea captain, and he knew what demurrage was. Demurrage is damages payable for a ship which is delayed in port. Ships only make money. You know this? Good Lord. Yeah, for delays in port, absolutely. Well, I am impressed. So demurrage, this was a case about the Suisse case was demurrage case, so it was nothing to do with breach. It was about exclusion clauses, but it wasn't to do with fundamental breach. And the judge in the Suisse case said, therefore, obiter dicta. What's obiter dicta? What's obiter dicta? Things said by the way, and that's distinct from the rationale of the decision, which is called ratio decidendi. You're going to have to know these things. These things do get asked. Okay, so the judge said that he saw no reason why it was not possible to have an exclusion clause so wide that it excluded liability for total non-performance, an absolute fundamental breach. And it came up in the case Photo Productions and Securicor. And the concept of exclusion of liability for fundamental breach was the basis of this case. Photo Productions is a film processing company. And Securicor, you know, they've taken over, or Group 4 has taken over Securicor or Securicor. It's an Absarzer company. Yeah, Absarzer. And Securico negotiated with Photo Productions. They negotiated a contract whereby Securico would be paid, and in exchange they would secure the premises of the Photo Productions company. This involved sending a man round 3 times every night. He would drive round at different times. He would vary the schedule. And on one of those 3 occasions, he was meant to actually physically go into the premises and check to make sure that everything was fine. There was an exclusion clause. The exclusion clause in the contract, which was written by Securico and agreed by Photo Productions, said, now listen, it said that Securico would not be liable for any loss or damage to the client's premises, no matter how caused. No matter what the cause was for the loss or damage, Securico were not going to be liable. Okay, the contract started, and Securico sent their men round, and on one occasion they sent a man who happened to be in love with the idea of fires. He was a pyromaniac. He loved fire. And his friends down at the local pyromaniac club said, where are you working? He said, I'm actually doing security around Photo Productions. And they said, you lucky man, because film, when lit, film is whoosh, it's brilliant. What an exciting time you can have. So the next time he went in, he got a little pile of sweepings from the floor and he put them in the corner, and sure enough, he lit them. Whoa, wonderful. Then he tried another pile, because it's not really a scientific experiment, is it? One is not necessarily is it always going to go whoosh. So he thought, well, I'll have another pile, and he lit that. And then he lit a third. And by the time the third one was lit, the first one had taken hold, and it was destroying the premises, the entire premises of Photo Production Company. Smoke, black smoke was filling the premises. He couldn't see the way out. He couldn't find his way out. And he bumped into things, and his glasses fell off. And this is serious. This is what happened. His glasses fell off. He trod on his glasses. He now is feeling his way. He finds the door, by which time the fire engines are arriving. They find this myopic man wandering around the car park, full of dust and dirt and smoke. And of course it comes to an argument. Whose insurance company has to pay? Is it the film company's insurance that must pay for the loss, the destruction by the Securico employee? He had destroyed the premises. Or should it be Securico insurance company that should pay? What does common sense tell you? Because that's probably wrong. Whose insurance company has to pay? Securico? No, it's the film company. There is an exclusion clause within the contract that says we shall not be liable for loss or damage, no matter how that loss or damage has arisen. We will not be liable. And it was therefore the film company's insurers that had to pay. Isn't law wonderful? I'm on to page 30, unfair terms. We've got the Unfair Contract Terms Act of 77 and the Unfair Terms in Consumer Contract Regulations of 99. And these actually put into statute what is considered to be fair and unfair. And they restrict, therefore, or limit the extent of liability for negligence in a consumer contract. What do you understand by the expression consumer contract? We've actually covered it this morning. What's a consumer contract? We came across it about 3 pages ago. Gunutta? Yeah, where the contract is by a person in business selling to the end consumer. That's a consumer contract. Some avoid. This is it's called an oxymoron. It's a contradiction in terms. An oxymoron is where, I'm being very brave here, but if I say women's logic, then some people would say that that was an oxymoron, that was a contradiction in terms, unless you put a negative in there. But I'm being very brave, and I don't mean it. I don't mean it. It's just an illustration. So an oxymoron here would be a void contract. You cannot have, it cannot exist. A void contract cannot exist. So it's an oxymoron, it's a contradiction within itself. Why can you not have a void contract? Because a contract is a legally binding agreement, and you can't have a void legally binding agreement. So what you thought was a contract may be declared by the court to be void, and therefore it's not a contract. Okay? So some negotiations, and I have to call them contracts, some will be declared void by the court. Others then become subject to a test of reasonableness. And you can't exclude liability for negligence in any contract. You can't exclude liability for negligence which results, as a result of your negligence, it results in death or personal injury to somebody else. And again, the past exam questions come up. The woman was getting married, and the father and the bride were in the back of the wedding car, and as they got out, the father fell over and injured himself. He fell over the lip of the car and injured himself. And the bride, as she was getting out, she shut the door and it caught her dress. And she walked away, and her dress stayed there, and there was the bride with no dress, and the dress obviously was damaged. So can the wedding car company exclude their liability? Well, they could in respect of the bride's dress, because that was not death or personal injury. But they couldn't exclude liability for the injury that the father suffered because he had fallen out of their car. So questions like that do come up, and you need to be aware. It's not possible, it is not allowed to limit or restrict your liability for negligence resulting in death or personal injury. You can't exclude liability for partial or incomplete performance by the seller. If the seller only partially performs, they are not able to exclude liability. The consumer must be protected. The end user, typically an end user, a private person. And therefore, why should some large organization, more possibly wealthy than a private individual, why should they be able to shelter behind an exclusion clause to the cost and the loss of the private individual? And so you're not allowed to exclude or limit your liability for negligence for partial or incomplete performance. You can't have a term within a consumer contract. You can't have a term which binds the consumer but allows the person in business, the seller, not to be equally bound. He said earlier on, the third bullet point, it says some are void but others are subject to a test of reasonableness, and reasonableness is specifically defined. We said yesterday that a reasonable time is a time which is reasonable. And giving notice for a meeting, you should give reasonable notice, which is reasonable, but actually for the purposes of unfair terms, the word reasonable is specifically defined or specifically explained. And so we've got reasonable schedule, I think, it's Schedule 11 of the Unfair Contract Terms Act of 77. There's no need for you to remember the schedule numbers, the section numbers, the dates. There's no need for you. But reasonable says it should take into account relative bargaining power. If you're in contract with your employer, by definition, they have greater bargaining power than you. By definition they do, because you're an individual and they're an organization. And therefore you do not have relatively similar bargaining power. But Photo Productions and Securicor are two big companies, and they are pretty well equal in their ability to negotiate and to bargain and and to discuss and introduce terms into a contract. As an individual, by definition, you don't have that equality of bargaining power. Any inducement offered, or whether it's normal trade custom, if we are in a situation of equality of bargaining power, what is the norm? And with reference to Securicor, it was normal for security companies to exclude or limit their liability. Apparently that's normal. If Securicor were to say to Photo Productions, these are the terms of our contract, this is the price you will have to pay, let's say £10,000 a year, but if you allow us to introduce a limitation of liability clause, we will only charge you £9,000 a year. Then if we've given an inducement, an incentive, a discount to the other party, so that they will accept the exclusion clause, then the court would probably say, yes, the exclusion clause is valid. Special ordered goods. If you're selling goods if you're selling inventory out of inventory, if these are your normal goods that you sell, then it's not reasonable for you to have an exclusion clause. You're saying our goods may be okay, but they may not be, and if they're not, then we want to exclude liability. So if it's a normal item out of inventory, it would probably be unreasonable to exclude liability. But if they're goods which have been specially ordered and specially made to the customer's specification, then you might expect a reasonable exclusion clause. If you're your normal goods that you normally sell every day, then there's no exclusion clause available. But if they're specially ordered or specially made, then it would be reasonable to have an exclusion clause. The fair and equitable treatment of the consumer by the seller. Remember, in consumer contracts, the end user should be treated fairly by the seller or by the service provider. And the extent of liability, which could have been covered by insurance, to what extent could either the seller or the buyer, to what extent, principally the seller here, to what extent could they have covered themselves by insurance? This is just another expense. They should have insured against the provision by them of faulty goods. That should have been insured against. There's a case, I seem to remember, St Albans, which is a town near London, city near London, St Albans and International Computers, ICL. And it was available for ICL to have covered themselves by insurance. St Albans lost something like 25 million as a result of the faulty goods which ICL delivered, but ICL should have been able to insure themselves. They denied liability, and St Albans said, no, you should have been insured against this loss. Regulations apply to terms which have not been separately negotiated, so they're implied. A consumer is a natural person who's acting for purposes not in the course of business, and an unfair term is any term which causes a significant imbalance in the parties' rights and obligations to the detriment of the consumer. There's a number of cases involving pop stars. Elton John was certainly in a case where inequality of bargaining power was the key, that his original manager or promoter or the original recording company knew that Elton John was broke. He had no money. He was looking desperate and busking in the underground railway system, trying to collect money to buy his next meal. And he was lured, and they signed a contract and persuaded him to sign a contract, which was a pittance, hardly any money at all. There was no real money involved. But because he was desperate, he signed the contract. But that's an inequality of bargaining power where they induced him to enter a bad contract. Sting was another one. Gordon Sumner. He was another one who was induced into a contract when he didn't have a lot of money. And by definition, the recording company, which buys the rights to all the music that Sting wrote and Sting sang, the recording company has a far greater bargaining power than the individual musician. And I think it was Richard Branson from Virgin Records who was the first to say to any new recording artist, he was the first one, I think, to say to this new recording artist or the group, you will go to an independent solicitor. I will pay, but you will go to an independent solicitor to make sure that I treat you fairly. And that then avoided any future dispute, any future expensive court cases. And I think it was Richard Branson that did that. But now I think it's common practice within the industry that any new recording artists or even new actors will specifically be told to go and get independent professional advice before they sign any contract, which seems fair.